So, welcome back to this second session of the CPLJ final conference. Just a few words about logistics. We will organize this session in pairs for the moment. So we'll have Tanya and Scott in the first place, and then Stefan and Rick, and finally Luca with his segment. They will speak one and then two, and then we will open the floor for questions for both speakers. I need to ask you to speak loud because we don't have any microphones. I don't know where they went. And for our colleagues on the back and for our colleagues at home, so we need to open up and use our teaching voices. So, without further ado, I introduce you, you all know her, Tanya Domek. She is Professor of Law at the University of Zurich, and she has been working in the segment devoted to the constitutionalization and fundamentalization, I don't know if I pronounce it correctly, of procedural guarantees, and under the supervision of Beate Gexel and Frédéric Ferrand. So, Tanya, the floor is yours. She will speak about the constitutionalization of access to justice.
Yeah, thank you very much. And I hope everyone can hear me. And if not, please let me know. Okay, great. So, first of all, I would like to thank all the members of my team for the very enjoyable cooperation. And I would also like to thank Yangwa and Jordi, who are here today as well, for helping me with the preparation of this presentation. What I will do today is that I will start with some general remarks about constitutionalization and fundamentalization, and then I will highlight some particular areas, which will be first the relationship between the judiciary and the executive branch, then the selection of judges, the principle of open justice, and finally some issues of appellate remedies. Now, our part is about the influence of constitutional law and of fundamental rights on civil procedure. Particularly, I would say in the 20th or since the second half of the 20th century, national constitutions and international or supranational instruments have increasingly shaped civil procedure. And maybe even more so, they have influenced how we think about civil procedure. The idea that constitutional rules and fundamental rights and principles have become and still are becoming more and more important for civil procedure shapes the title of our segment. If we talk about constitutionalization and fundamentalization, this indicates that there is some kind of progressive development. But we have to acknowledge, of course, that this development is not always smooth, and that there is always a possibility to go backwards. And the unstable political situation in many parts of the world in recent years has made this very clear. And we can see the rule of law coming under threat even in parts of the world where it used to be strong. Now, some constitutional principles, such as the independence of the judiciary or the principle of open justice, are quite old indeed and related to the end of absolutist monarchies. And broadly, one can probably say that institutional guarantees for the independence of the judiciary from the executive branch are the oldest layer of constitutional guarantees that relate to the judiciary. And I would say that the principle of open justice comes alongside this, because making sure that justice is seen to be done was also originally meant to ensure that a monarch cannot unduly influence court proceedings. We could talk about the independence of the judiciary, particularly the institutional independence of the judiciary as a matter of a power struggle between branches of government. And of course, this has become a very common way of talking about this. And wherever the judiciary becomes perceived as more activist, this aspect increasingly becomes a matter of public discourse. This has become very obvious in the US, I would say, where the Supreme Court in its recent case law has radically reshaped the relationship between the executive branch and the judiciary, and has claimed much more authority for the judiciary and particularly for itself. And many would describe what is happening, or they actually do describe what is happening, as a judicial power grab, particularly because the conservative majority of the Supreme Court, you may confirm or deny that, seems to be very interested in achieving certain ideological goals and outcomes, and is prepared to achieve them, I think, at the expense of the traditional principle of stare decisis, and also maybe without following a really consistent legal methodology. But in Europe, we can actually see a similar debate unfold, although the ideological roles are a bit reversed in Europe. Because we can increasingly see conservative and right-wing politicians as perceiving progressive rulings from especially international and supranational courts as problematic judicial activism. And in some jurisdictions, this has even led to calls to leave the European Convention on Human Rights, that has been the bedrock of what we are talking about in Europe since the 1950s. And in other jurisdictions, of course, the executive seems to have a stronger grip on the judiciary. And often this is actually less a matter of the text of constitutions and rather a matter of de facto political power. For example, in China or Russia, although there are constitutional rules on judicial independence, external interference and pressure are reported to be common problems for courts. But as I have indicated, in many Western jurisdictions, politicians are also increasingly trying to put pressure on courts and are publicly portraying judges as enemies of the people. And such debates and power struggles do often relate to public law issues, but nonetheless, civil law, private law, and civil procedure are not immune from such debates. Particularly, this becomes more salient the more civil proceedings are used for strategic goals, as is, for example, happening in the field of environmental law. Now, directly interfering in judicial proceedings is, of course, only one way, and indeed a rather inelegant way of influencing the outcome of judicial proceedings. It's much more convenient if those who want to influence the judiciary, if they can simply pick judges who will presumably implement their preferred policy. And insulating the judiciary from interference in particular individual cases and protecting judges from removal for political reasons, of course, is only part of the puzzle, of how to ensure the independence of the judiciary, if we understand that as a sort of ideological neutrality, if there even can be such a thing as ideological neutrality. So there is a range of models for the selection of judges that we looked at. There can be election by the general electorate, there can be election by a legislative body, this can be on a partisan or on a non-partisan basis, there can be appointment by an executive organ, and there can be appointment or selection by an independent organ. And none of these methods are per se incompatible with the independence of the judiciary or with the law, with the right to a lawful court, as it is enshrined in the European Convention on Human Rights and in many national constitutions. But in Europe, one can recently observe an increasing drive to insulate the selection of judges, especially from the executive, but also from the legislative branch. And I would like to highlight this development. The lawfulness of the appointment of judges or of the removal of judges has recently been the focus of a number of high-profile cases, both of the European Court of Human Rights and the European Court of Justice. And the European Court of Justice has stated that it is inherent in the very notion of a tribunal that it be composed of judges selected on the basis of merit, and has thus indicated that qualitative criteria for the selection and appointment of judges are an element of the lawfulness of a court. And if the judges were not selected in this way, a party could actually bring a successful complaint to the European Court on Human Rights against a judgment that was given by the unlawfully selected judges. And the European Court of Human Rights does seem to allow a margin of appreciation for contracting states, but it does not yet seem quite clear how much potential this case law has to actually destabilize some of the systems for the selection of judges. In Switzerland, for example, most judicial positions are filled based on affiliation with political parties. And there was a ballot initiative in 2021 that was aimed at depoliticizing the federal court, so the highest court in Switzerland, but that was rejected by a really large margin, more than 2/3. And given what we have seen with the recent Klimaseniorinnen case, I would not like to know what would happen if the European Court of Human Rights were to say that the whole Swiss system of selecting judges is contrary to the European Convention on Human Rights, and that therefore you can successfully attack any judgment given by any Swiss judge. I don't think this would go down well. But also, places like Germany do not adhere to a system such as that, that the European Court of Human Rights thinks is the optimal one for selecting judges. So this certainly remains a field to be watched, particularly if the tensions between the judiciary and the executive that I mentioned earlier continue to rise. Now let me briefly address the principle of publicity or open justice. That can also serve as an example of the continuing evolution of constitutional or fundamental principles. As I already indicated, the principle of publicity arose in reaction to the secret judicial proceedings that prevailed in both common law and continental legal systems until the 18th century. And having trials that take place in the open was perceived as an antidote to this sovereign interference, but also to the preferential treatment of privileged parties. But of course, having open justice in the 18th or 19th century is not exactly necessarily the same as having it in the 21st century. Of course, technology evolves and new issues arise relating particularly participation remotely or following trials remotely. This has been implemented in some jurisdictions, but there is a lot of pushing back in some other jurisdictions against allowing that. And I think it will be very interesting to follow that in the future, particularly also because there is a tension with the tendency to emphasize more and more written elements of the procedure, and also a growing desire of parties to keep their disputes confidential. There is a clear tension between the principle of open justice and the right to privacy or right to data protection that has also emerged or is emerging in many jurisdictions as a constitutional or fundamental rights. Finally, a few words on appeals from a constitutional rights or fundamental principles perspective. There are very different approaches to this, obviously, also around the world. Some jurisdictions explicitly recognize a constitutional right of appeal. Others take it for granted that there is such a right. And finally, there are some that do not mention the issue at all. And this seems to be generally a reflection of like historical reasons in the respective jurisdictions. And our chapter on appeals, on remedies, deals both with national approaches to appeal and with appeals to supranational courts, particularly the European Court of Human Rights, the Inter-American Court of Human Rights, the African Court of Humans and People's Rights, these that have also come upon the scene. Now, Jordi Nieva-Fenoy, who is the author of this chapter, argues that the right to appeal should be expressly constitutionalized and that excessive formalism respecting the admissibility of appeals should be removed. And he is in particular skeptical about a system of certiorari that does, of course, enable an effective management of higher courts workloads, but at the same time can lead to arbitrariness. Also, Jordi argues that appellate courts should not be limited to reviewing points of law, but that their cognition should include questions of fact. You can see there. You can see, therefore, that he is a strong proponent of the right to appeal as a means to protect individual rights. And that goes against a certain trend of seeing appellate courts mainly as institutions that are responsible for clarifying and developing the law and for ensuring a uniform application of the law. And this understanding of the function of higher courts is no longer limited to case law jurisdictions, if it ever was limited to them. For example, in Germany, there is currently a legislative debate on creating a leading case procedure before the Federal Supreme Court that would enable that court to make clear guidelines for the application of law, even if a case becomes moot. An alternative proposal is to enable the Supreme Court to make preliminary rulings, similar to the European Court of Justice. And I understand that such a procedure already exists in the Netherlands and that it is widely used there. I'm not sure that I would fully subscribe to Jordi's highly individual rights-centered approach to appellate remedies, but I also do have some concerns about decoupling Supreme Court's decisions from individual life cases. And I think to round up my presentation, the development in the United States I think can also serve as a kind of warning against making Supreme Courts too much decoupled from live cases. And with that, I thank you very much for
Thank you very much, Tanya. See if we can get the presentation coming.
Here we go. Okay, great.
So Scott Dodson is professor of law at the University of California, Law San Francisco, formerly known as UC Hastings. And he's been working on the segment dealing with jurisdiction and venue, very closely together with the coordinator, Peter Tran, from the University of Hong Kong. So Scott, the floor is yours.
Thank you. This is going to be by far the most interesting presentation of the day. But I wanted to give you a little bit of background about how the part has developed, and then talk a bit about some of the contributions that I have made in my own chapter. So I'm sharing the work of 6 people. That's me, Peter Chan, Kamalia Metiyeva, Mohammed Peleker, Giovanni Priori, and Katerina Silvestri, from a variety of different countries and continents even. And I wanted to talk first a little bit about what the whole part is doing, to give you a sense of the overarching themes and goals that we've come up with, along with some discussion of each individual chapter. And then I'll talk a little bit about my own, to give you an idea of the analyses and insights that we draw. So first, a little bit about the part in general. Our part begins with the observation that within each country, the allocation of judicial authority among courts represents a fundamental feature of any civil justice system. So our part focuses on the domestic allocation of civil cases through the legal divisions of jurisdiction and venue. And it offers, I think, a rich descriptive landscape of the varied and the multifaceted ways that different countries have approached case allocation. Now, allocations can be viewed through different lenses. So structurally, allocation can be vertical, so dividing courts within a single system into hierarchical levels, or horizontal, so dividing courts of the same hierarchical level into geographic regions or subject matter specializations. It can also be valuistic, in that allocations can reflect normative goals of efficiency or competence or access to justice. And developmentally, judicial allocations are often a product of historical or socioeconomic and political influences that have evolved within a particular nation over time. So we aim to describe the allocation choices that various countries have made, and we touch upon more than 50 different countries from all 6 populated continents, though we focus our attention on the countries that we know best: South Africa, mainland China, Peru, France, Germany, Italy, the UK, and the United States. The part also offers assessments and critiques of countries' case allocation. So where some have succeeded in their aspirations, and where others have failed, and where some are still developing. And we provide some insight by categorizing common features of case allocation across countries, pointing out cross-border influences, and contemplating domestic case allocation in an increasingly global legal community. So, as these preliminary remarks have no doubt led you to suspect, our part is necessarily interconnected with other parts in the compendium, including judicial organization and independence, access to justice and the cost of litigation, due process, the structure of litigation, appeals, judicial review, and special subject matters, among others. And some overlap with our part is inevitable, but we think the overlap is actually enriching, because the issues that overlap show just how rich these core questions are, and what broad implications that they have for all different facets of civil justice. Okay, so we divided our part into 6 chapters. Chapter 1 sets the stage by describing, analyzing, and categorizing constitutional allocations of judicial authority. It asks and sometimes answers why countries would constitutionalize certain allocations rather than leave those allocations to the legislative, executive, or even the judicial branches of government. Chapter 2 explores the doctrinal categories of allocation by detailing approaches to territorial jurisdictions, geographic allocations they empower and sometimes disempower courts within the bounds of a particular geographic territory to hear cases over events or persons. If a court doesn't have geographic jurisdiction over the events or persons within it, then the court cannot bind the defendant to an obligation or adjudicate any rights involving them. This kind of jurisdiction is to be distinguished from subject matter jurisdiction, which is the power of the court to render a judgment concerning a certain subject matter. So this chapter compares and contrasts different regulations arising from allocations of cases based on geography. Chapter 3 turns to a description of the various systems and rules governing the determination of jurisdiction by objective criteria, the nature of the case, the economic value of the matter in dispute. It also analyzes the quantitative and qualitative aspects of these criteria. It compares the different criteria across the globe in allocating cases according to the case type and financial aspect of the case. Chapter 4 describes the different solutions adopted by legal systems to deal with parallel proceedings, depending on their jurisdictional background. The general purpose of jurisdiction in civil law systems is to ensure the proper administration of justice. This means ensuring the predictability and certainty of the rules of jurisdiction and competence so that each citizen can know in advance before which court he or she can sue or be sued, depending on the specific characteristics of the dispute. In parallel litigation, in addition to the objectives of predictability and certainty, the main objective is to avoid conflicts of judgments, especially where the pending actions are identical, like these pendens. The civil law approach to the issue of parallel proceedings has been adopted in the European Union within the framework of the constitutional traditions of the member states, where the legislature and the case law have developed solutions capable of harmonizing the different frameworks of the various responses to parallel litigation. In common law countries, criteria of territorial connection can help determine the competent court. However, the common law is characterized by the considerable discretion of the judges in modifying the rules for staying or dismissing the case, such as in the doctrine of forum non conveniens, and by the specific remedies developed, such as in the anti-suit injunction, in order to achieve the best result. Chapter 5 examines the topic of special jurisdictional courts. In order to explore this topic, the chapter addresses a number of questions, such as which specialized courts seem most important to these national systems, which criteria are used in order to assign a case to a specialized court rather than to a general court? Does specialization of a court come as an exception to the common jurisdiction of courts? And are there difficulties in assigning the case to specialized courts? Chapter 6 delves into the subject of transferring a case from one venue to another within a country. So again, these are not international transfers, and analyzes the factors that can influence a court's decision to do so. It looks at both civil law and common law jurisdictions to identify similarities and differences between them. Transfer can provide a solution to many of the issues raised in previous chapters in this part, including when the case is filed in a court of improper venue or improper jurisdiction or competence, or when the case is subject to parallel proceedings, or when the case should be heard by a specialized court. So ultimately, all of the chapters in this part document that domestic case allocation reveals both stark differences and surprising commonalities among countries' approaches to the design and implementation of civil judicial systems. And they show just how fundamental jurisdiction and venue are to effective and efficient civil justice around the globe. Now, let me tell you just a little bit about my chapter, since I'm the one here on the hot seat. On constitutional allocations of judicial authority. I won't go through all of the descriptive material, but instead I want to focus on a few of my main takeaways. So a country's choice to constitutionalize case allocation, I think, has two related implications. First, because constitutions are more difficult to alter or amend than ordinary legislation, constitutional case allocations are likely to be more static than case allocations directed by ordinary legislation. Most case allocations in the US, for example, under the US Constitution, have persisted unchanged for more than 200 years, except as modified through constitutional interpretation by the courts. Second, and this isn't necessarily corollary to the constitutional stasis point, is that constitutional case allocations are usually less detailed and less directive than statutory case allocations. Many countries, for example, constitutionally establish only a high court or a small set of high courts and leave the creation of all other courts to the legislature to develop as that best serves the needs of the country at the time. Further, constitutions tend to be less detailed about the case allocations to the various courts, again, leaving those decisions to be made by the legislatures. Taking these two implications together means that trends and multinational convergences in case allocation, jurisdiction, and venue take place primarily through ordinary legislation and supranational law like treaties or conventions, which can operate in the space created and left open by individual constitutions. Nevertheless, a study of constitutional case allocation itself does reveal insights about the world's judicial systems. One of those is the level of similarity that pervades the constitutional allocations of cases across the globe. Nearly all constitutions, for example, establish at least one ordinary court as a way to guarantee a judicial branch of government, providing a public dispute resolution function. Without the constitutional establishment of that court, the political branches could abolish the courts and take the judicial power for themselves. So constitutionalization is crucial for judicial independence. Further, constitutions typically establish, either explicitly or implicitly, a vertical system of courts structured to exercise tiered levels of review. So vertical structure gives the judicial branch form and mass and legitimacy, while at the same time providing a triage system for improving the efficiency of the higher courts. Another commonality, with only a few exceptions, is the general lack of constitutional case allocation based on party status or relief sought. Those kinds of case allocations tend to be created entirely by ordinary legislation, likely to allow for flexibility to respond to changing demographics and economics. So these similarities are at a particular level of generality. At levels of greater specificity, differences begin to reveal themselves, and those differences also reveal insights about case allocation in the various countries. So some differences are motivated by the country's governmental character, including its level of commitment to constitutionalism and the separation of powers, or to federalism or local autonomy, or to separate religious or indigenous communities of particular importance to the demographics. The commitment to constitutionalism and the separation of powers is reflected in how constitutions protect themselves from tyrannical political organs. One way is for the Constitution to give the courts or a specialized court the power to resolve constitutional disputes and exercise the power of constitutional review. Countries whose courts lack this authority must rely on the political process to check governmental overreach. The commitment to the separation of powers is also reflected in the varying scopes of constitutional grants of jurisdiction. More constitutionally guaranteed judicial authority means less power for other organs of government. At one end of the spectrum, for example, India's constitution gives its courts both judicial independence and the authority to decide many political matters, resulting in a strong judicial branch. At the other end of the spectrum, China gives the scope of the court's jurisdiction entirely to the discretion of the National People's Congress, which is a choice consistent with the governmental structure dominated by the political powers. Federalist governmental structures and commitments to local autonomy also influence constitutional case allocation. So federal countries like Australia, Brazil, Canada, Germany, and the United States use constitutional case allocation to balance the need for national uniformity and supremacy of national law against the need to retain a prominent role for local judicial systems. Such constitutions often grant jurisdiction over cases with national implications to the federal courts and appellate jurisdiction over local judicial systems to a higher federal court. Other differences are driven by variations in country sizes or population demographics. Countries of particular large size, especially large countries with federal structures, are more likely to constitutionalize case allocations based on geography. Brazil, Canada, and the United States are good examples. Some countries with religious or indigenous populations have constitutionalized special courts to address issues arising from or important to those particular communities. Finally, constitutional differences can be explained by history, culture, and tradition. The development of constitutional courts in particular reflects highly individualized stories about history, geopolitical power, and internal politics. Meanwhile, mimicry in other constitutional designs often follows shared common law or civil law traditions or geographic proximity. The common law civil law divide helps explain some general divisions among constitutional case allocation choices, such as whether case allocations based on geography should be constitutionalized or left to the legislatures, or whether judicial review is diffuse throughout ordinary courts or is concentrated in a constitutional court, and whether subject matter specialized courts are left to legislatures or are constitutionalized. So my chapter, and along with the other chapters, comprise this entire part, and they reveal and offer a framework for understanding the similarities and differences among nations regarding the allocation of cases. Thank you.
Thank you very much, Tanya and Scott, also for sticking to time. We open now the floor for questions and comments. I see Christoph. I would ask you, those intervening now, to stand up and introduce briefly yourself. So tell us where you're coming from.
Christoph, and I'm from the crowd segment or cross-border team. I work at the Court of Justice. And I have a question, if I may, to Tanya. And to what extent you were able to address your chapter and your segment, access to justice, and its constitutionalization in the context of the new trends? What I mean by that is, first things, whether the judge has an access to justice, and I mean in the context of rule of law cases. There's a huge discussion nowadays to what extent a judge should be able to enforce the rule of law, try to secure it by way one another, but through procedural means. So whether they have access to justice. Another thing, to what extent the constitutionalization of access to justice corresponds to the AI. I know it's a big word, everyone talks about it, but there might be some things going on that line too. So that would be delightful if you could mention that. Thank you.
Yeah, thank you very much for the question. So I did briefly address the issue, particularly of whether judges themselves have recourse against being unlawfully removed, because that is one of the prongs of the, particularly the European Court of Human Rights case law, where you have on the one side the possibility for the parties to attack a judgment that was given by an unlawful court, but there is also some possibility for judges, of course, to bring complaints based on that. And I did address that briefly. I think it is a matter that is only adjacent to civil proceedings, but I did try to address that in my chapter. Now, as regards AI, this was not my focus in this chapter. I do think that it is, of course, an important topic that will have to be addressed, that already has to be addressed. And I think there are many constitutional challenges, and I think some of those constitutional challenges concern individual rights of the parties. The question whether a party's individual right to access to a court can actually be fulfilled if there is not a human on the other side. But I personally actually also see an even more salient challenge in the question of the whole structure of the judiciary and the relationship between the judiciary on the one hand and other branches of government on the other hand, because I think that there is kind of a potential to making the judiciary much more top-down than it is now if we have some kind of AI saying what the solution to cases should be. But what I also have to say, I think it is important to look at these developments and to reflect on these developments, and also to see the risks that come with these developments, alongside, of course, also the opportunities that they bring. But I think to some extent it is really difficult to tell how exactly that will unfold, because just recently we saw that study, maybe you've all heard of it, from Stanford, about the AI research systems where you have like a quota of, I think, 15% mistakes, just making up of cases. Yeah. And I think it seems, if I understand this technology correctly, I'm not a software engineer or whatever, but if I understand it correctly, that is something that is inherent in this technology. So it's not as if generative AI will tomorrow take over from the judges. I think that is not realistic. But nonetheless, I think we have, of course, to watch this development, to discuss the development, and also to think also about other things than generative AI, because there are, of course, also other types of algorithms. And I think one has to look at this very carefully, because it has the potential to undermine, I think, the judicial system. But at the same time, it also has the potential to create good things. And I think one has to find the right balance there.
Thank you, Tanya. Please. Yes.
Thank you very much. Very interesting to say. My question is for Scott.
Can you introduce yourself, please?
Oh, sure. Gerard Kennedy, University of Alberta. You did a very interesting discussion about how jurisdiction is given to judges at an institutional level. Did you any looking at how that happens at an individual level? So, for instance, you have 30 judges in the Northern District of California who hear the civil case. How do we know who gets it once you are at that level? It's my understanding that in most common law jurisdictions, the chief judge or justice will assign it. I see that's preferable than having the legislature sign it, but I also don't know if the chief judge and justice should be mucking around too much, for use a very scientific phrase. And I guess the flip side of that, have you ever seen instances where the legislature has defined it to such a level that it knows only one judge will get it?
Germany.
There's an area in northern Texas, I see Rick really wants to get in, but there's an area in northern Texas that we know who's going to get it.
Yeah.
That also seems problematic at the other end of the scale.
I believe our part does not deal with the assignment of cases to individual judges. Yours does. Perfect.
Oh, okay.
So,
sorry,
so maybe Tanya can answer the question too, but I'm happy also to say just briefly about what some of those issues from the U.S. perspective. So normally the case gets filed in a particular district, which is composed of multiple judges, and there's a random assignment, usually, of the case to a particular judge. Now, there can be non-random assignments if there's a particular related case, and there can be other kinds of non-random transfers of cases from one judge to another judge, where it's a specific transfer to a specific judge. But in general, the process is designed in the federal courts and in most state courts to have some randomness aspect to it, so that you're not judge shopping when you're forum shopping. Now, there are some districts, though, that are composed of just one or two judges, or that the districts have a subject matter specialized assignment system. So there was the district in the Eastern District of Texas, of all places, became a hotbed for patent cases to be filed there because it had some judges who became very patent claim friendly. And moreover, there was one judge in particular that was sort of became the expert in these, and the assignment process tended to funnel all of those cases to that particular judge. So you kind of had a 70% chance of getting that particular judge. And that particular judge was going to be very friendly to patent claims. The Supreme Court finally corrected that by reinterpreting the venue statute that Congress had provided. So you can't just file in the Eastern District of Texas for all these patent claims. But that remains a problem in very discrete areas. And we see this now in the Northern District of Texas, where states, even those that aren't Texas, are filing cases in this particular district because they know that it's going to be assigned to a particular judge who's going to be very friendly to them. An add-on.
If you're going to talk about that, can I provide specifics? Because we, 19 U.S. senators wrote to the chair of the Advisory Committee on Civil Rules last June, saying, do something about this, particularly Judge Kaczmarek in the Northern District of Texas. There are various proposals. Single judge divisions were created by Congress. And Congress said chief judges of a district can assign cases. They're normally random, and it is a bottomless pit of political controversy, depending on which side wants to have random assignment and which side doesn't. The Judicial Conference tried to promote it. Republican senators threatened judges, chief judges, because of that effort. This is really a ticket. So you're right. It's a problem, but it's not easily solved, and it's unique to us.
I don't think it's unique.
Tanya, you wanted to add something?
Maybe just briefly, I mean, Germany, of course, is kind of the obvious counterpoint to this, because the traditional approach in Germany was that it has to be completely predetermined, first by law and then by the internal rules of the court, which specific judge will deal with the case. And judge shopping wasn't as easy, of course, as in the US, because you couldn't just simply choose which courts to file in. But nonetheless, if you knew I'm going to file in that court, then you also knew which judge you were going to get. This has reduced a little bit because for the better kind of caseload management, many courts have now introduced a way of allocating cases kind of sequentially, so there is a certain sequence of judges, and you know that when the cases are allocated in turn. Of course, this system of case allocation, the random or chief judge assignment, maybe can help, particularly the chief judge assignment, to have specialist judgments for certain issues, but that is something that Germany is actually traditionally not particularly friendly to, this idea that one judge is going to specialize on certain kinds of cases. But I think that although these systems come from so different starting points, actually similar issues do arise, because in Germany there are also courts that kind of become specialist and preferred courts for certain issues because of the way that the case law works there. So I think there is really no easy solution for this issue.
Thank you, both of you, for this interesting talk. So I think first Eduardo, you were first, Eduardo? Yeah. Can you, Eduardo, please stand up? And, yeah.
Eduardo, please. My concern is probably not your chapter, but I'm concerned about the access to justice as fundamental right.
Yeah, it is.
It was particularly strange for me to see the special reporter last year, especially remark and highlight the quantity, the enormous quantity of people without access to justice. And also there is in the 2030 agenda this issue. And I don't know how much the segment advanced in the progress of the advance of it.
I think that this is very difficult because it is not only a legal issue, access to justice, because we are actually dealing particular with access to courts, and that is in a very large degree more a factual economic issue. It's an issue of the availability of money in many places. And I think that this is not an issue that can be solved by making some legal proposals. I don't see what these could be. Of course, I mean, I deal with legal aid. I deal with collective proceedings, with things like that that can facilitate access to justice, but also, of course, in the case of collective proceedings, come with some challenges of their own. But I do not see how I could actually make legal proposals to solve this, because I think this is a matter of resources to a high degree. I am not friendly to solutions that say, but I think this is something that will be addressed later on. Again, I am not friendly to solutions that say, to solve the access to justice problem, let's just do away with access to courts and let's do something completely different. Let's have different institutions. Let's have different institutions that use different processes, that do it in a somewhat completely different way. I think that this can supplement, of course, access to courts, but I don't think that this is a solution to access to justice, to say let's have some completely different procedures and let's have different institutions that do not have to meet the quality requirements for courts.
Can I react?
Of course.
It's difficult to have the practical solution, but it's also easy to hide them the problem. And my perception is when we don't have the solution, at the same time, we exclude the possibility of discuss the issue. And when there is a real concern, I think that this is something that the academia must discuss. Nevertheless, probably we have the easy solution in terms of even practical answer to that question.
Yes, but absolutely, I agree that we need to discuss and highlight this issue. I think I'm doing nothing. I've been doing almost nothing else for the preceding few years in all sorts of venues, highlighting that, of course, there is a big problem, there's a big issue with large segments of the population not having access to justice. I absolutely agree. But I'm afraid that this is really largely a resources problem, and that by discussing how we could structure the proceedings differently, we're not going to solve it.
If I may, and if you allow me here, because access to justice is a topic that was also addressed by Sabrine team. And we do have here the author of the chapter, and maybe you want to add something, Maria Luisa? You will excuse me for this.
Come on up.
Yeah. Well, I think we were lucky because we have deal with the same topic, access to justice, but from very different perspectives. So you have focused on the constitutionalization, and I focus on access to justice, new trends in access to justice. And it is true that perhaps, well, if you read the chapter, I tried to look in different countries some new trends, some new possibilities, new options to improve access to justice. And for example, one of my topics that was proposed by the segment was how to improve for vulnerable people. So, well, sometimes it's not just legal solutions. Sometimes the solutions came from NGOs or from different institutions, or well, I have to study, for example, even in Africa, I know that they have different projects to try to improve access to justice. So, well, it could be not very easy to summarize, but I suggest that perhaps if you read our segment and our chapter, perhaps you can have some possible things. Thank you.
Thank you, and excuse me for this assault. That's good friends. Maria Luisa Villamarin comes from the Complutense, which is my university as well. So we know each other well, and I know her chapter, and I know how to do with your question, Eduardo. So that's why I entered that. So I don't know. Is it about access to justice, Alan, again? Because I think Remo has a remark.
It was just a follow-on remark about Uteza, Eduardo remark. It was Eduardo read fully in my mind. We, you know what? Our project is something to be compared with something like the access to justice of Mauro Castellino. Now, we should avoid the risk think from an outside perspective that we, as scholars in civil procedure, we are somehow stepping back due to some general political economic development, the going away from a welfare state to neoliberal tendency. We should, from the very beginning, make this point with access to justice, because my impression is that reading this from an outside perspective, or a perspective outside of our community, one might say, you know what? 40 years ago, the scholars in civil procedure were talking about access to justice. Now, they are somehow stepping back from this and talking more about allocation of cases, access to court, and you see, now comparing yet the social difference between now and then, we are seeing more and more inequalities in the world. And I mean, this is a problem maybe for a question to be made right in the beginning in the general introduction, because otherwise we could have this impression. So when we are stepping away from our position, of course we are all scholars in civil procedure, we are specialized in code. We need so assuming an example.
But maybe if we may say, I don't think so. From my perspective, this project is not kind of solely an access to justice project. It has many facets, and this is one of the facets. And we have two parts, at least, that deal not only two, we have more of those. We have collective proceedings, we have digitalization, everything. And I think, but what it is not is like a big project with the title Access to Justice, because it is broader than that. And I do not think that we can kind of call into question the whole project by saying it is not a project that is entitled Access to Justice, because I don't think that it's the same.
My point of view was, you should be clear. We cannot solve the problem, of course, but we have to be aware.
Yeah, but Marianne is a chapter. Exactly. Yeah, exactly.
This issue. Just to wrap up this thing, and we might then put access to justice to one side. I just recall there's the global project on access to justice, and Brian Garth is involved in this project. So there was a nice website. So there's a specific global project on access to justice. So Alan, please.
Yes, maybe further to Stella. I think that we've heard many very inspiring remarks. For me, it was striking that we had quite some overlapping, because it seems that some topics are re-emerging. And I don't see that as a great problem, but methodologically it will be interesting to see how to deal with these issues. And also what you were, Danya, presenting was very much overlapping with the Lima Congress last year and some of the reports that were dealing with it. My question here methodologically is how to deal with problematic points regarding constitutionalization and probably some other issues. Specifically, well, one point which might be interesting and finding a way how to deal with it is the relationship of judicial power to checks and balance doctrine. It is nowadays, I think, very hot topic because there are strong voices arguing that the judiciary is beyond checks and balance doctrine, and well, even the whole political organizations, maybe even Council of Europe in the European context, are going down that line. So the question is how to deal with that and whether it creates isolationist attitudes of judiciary, which is isolating judiciary from society. And that would be against what Cappelletti once was arguing for. Checks and balances is fundamental also when it comes to a position of judicial power. So that's one point. The other point, a controversial point, which you have yourself indicated by pointing that there is a member of your group that was arguing that the right to appeal should be very drastically constitutionalized. And I think it's a very interesting suggestion. I'd probably go into completely different part, and I would enjoy to discuss with Jordi about that. I think that constitutionalization of the right to appeal is the most fundamentally wrong thing in Italian tradition. And I think that the fetishism of appeals in my own legal tradition is something that is very wrong. But now the question is, if we are producing a compendium, should we then, and it's not bad to have different views, but maybe then we should be flagging all of the views so that the readership can then deal with such matters. So it's a question probably for the editors. And finally, just a remark for Scott, maybe it could be noted that not only judges can be randomly allocated, even the whole courts can be randomly allocated. We have in Croatia a rather interesting system according to which appellate court that is going to be competent is going to be randomly assigned in the country. I don't know if this is something that exists someplace else. It's maybe a very parochial thing, but it might be interesting as well.
Thank you. We don't have much time, so I would ask you to be very brief in your answers or your comments, unless Jordi wants to respond. So I will just give the floor.
I would briefly give this perspective, how we approached it and what our understanding was that the general approach here was. We have a very wide range of views and perspectives, I think, on many issues in this project. And I think our chapters and also the other segments are works of individual scholars who are indicated as authors of the respective parts. And I think that is good. I think it would be incredibly boring to have a compendium only things that we can all agree on. I think it becomes very clear in the various chapters that there are different perspectives on different issues.
Thank you. Yes.
I think Alan's comment was excellent.
Thank you. Jordi, you want to say something? It's on you as well.
Well, just very briefly.
Can you please stand up?
Well, my voice is very low.
So everybody can speak. Yeah.
No, anyway, what I wanted to say about constitutionalization of appeal, we have to consider which kind of appeal we are speaking about. If we are speaking about appeal before the Supreme Court, I'm completely agree with you. Well, it's just in Italy, it's perfectly the model. But I mean, if we are talking about a second instance, I think it's not a bad idea to have it constitutionalized in order not to let the parliaments say, well, up to now we are going to have just a first instance system in our country. We are not all going to have any more appeals. And I think appeal is a good thing to have a better justice, to have the possibility of correcting errors, to make judges not feel that they are superpowered or independent, not in the way they think they are now. They think they are absolute power, as the monarchs were in other times. No, they are independent. because we don't want them to suffer from influence, also from ideological influence from inside of themselves. And this is one of the biggest problems we are dealing with now, not only with the outer influences. So, what I wanted to say is to constitutionalize a second instance appeal, not at all the cassation system or that appeal.
But that's,
I think it's enough. Yeah, I think so. Thank you all for this good discussion. It's been great. We will continue in 2 minutes. I will ask now Stefan Huber and Rick Marcus to come to the stage,
But
please.
stay at your place.
Yeah, don't move, please. Yeah, yeah, yeah.
Yes, there is.
Yes.
Okay.
Oh, you need straight, so you use the lectern. That's fine.
So I take a contrary request for my part. Can we turn that off?
He needs that.
No. For my part, he goes first.
Yeah.
After that,
Yeah. Let's do that.
because he can't see faces with that big bright thing behind him.
When we possible to turn it off, just for a bit. We want so I oh, you have them not. Oh, here it is. Can do this.
What's that?
Oh, it's
What's that?
Mike. For those listening. Yeah. You're gonna sit or
I just need room to put 2 pieces of paper down. No, yeah.
oh,
I can have them one on top of the other. I don't care.
is that okay?
Yes.
So. So he will continue now. We can. So it is my pleasure to introduce to you to Professor Stefan Huber from the University of Tübingen. You all know him, but it is my pleasure anyway. And he's been marvelously leading the team or the segment on the structure of civil litigation, of civil procedure. And I had the privilege to work in his team. So thank you for that, Stefan, and welcome. And the floor is yours.
Thank you so much, Enrique, for this very kind introduction. Dear colleagues, dear friends, before I turn to the content of our part 6, I would like to briefly introduce the members of our team. I had the pleasure to work together with Tanni Bardo from Togo, living in Germany, working in Luxembourg, Alucio de Castro-Mendes from Brazil, Ales Galic from Slovenia, Linda Malinex from the United States, Texas, Yannick Novak from Belgium, Anna Nylund from Norway, Enrique, and we have the luck to cooperate with other colleagues, Shiro Kawashima from Japan and Majid Burustat from Iran, living in Canada. So I would like to proceed in 2 steps in order to give you a brief impression of the content of our part 6 on the structure of civil litigation. First, I would like to give you a brief overview of the general structure and the general approach of our team. And in the second step, I would like to describe, to present 2 specific problems in more detail. So we have decided to divide our part into 4 chapters. The first one deals with the procedural rights, principles, and approaches that might have an influence on the structure of civil litigation. The second chapter is about the different stages of the proceedings. That means that we have analyzed in which chronological order the different pieces of the procedural puzzle are put together. And in the third chapter, we discuss the role of the court, in particular with respect to early resolution and settlement. And our last chapter is dedicated to the role of the parties and their representatives. The basis of our analysis were reports from Belgium, Brazil, Germany, Iran, Japan, Norway, Slovenia, Spain, Togo, and the United States. And certainly we have got additional information about different procedural systems from Africa, Asia, and Europe, in particular about the English system, France, about the Scandinavian countries, and countries from the Middle East. The first special problem that I would like to share with you, the first special observation, concerns our first chapter. And in order to give you some background, I would just like to briefly introduce the structure of our first chapter. We have divided this chapter also in 4 subdivisions. The right of the parties to present their case, the principle of concentrated presentation of facts and offers of evidence, the public character of the proceedings, and here we have indeed referred very much to chapter 4 presented by Tanya just before. And finally, our last subdivision deals with the written-based and oral-based approaches. And the special observation that I would like to share with you concerns this last subdivision, written-based and oral-based approaches. Traditionally, we have a clear distinction between written-based and oral-based approaches. And we can observe that during the 19th century, many legal systems shifted from a written system to an oral-based system. So the question is, what are the objectives of written and oral elements? Written elements are said to be a better basis for decision-making. Why? Due to their certainty and clarity. Indeed, if something is written down, it cannot be forgotten. It is more difficult to manipulate this information, so it's a very clear basis for decision-making. Oral elements are said to guarantee for the parties, if it's natural parties, their day in court. In other words, their right to be heard. And it is true, I think, if we talk with natural parties, they might be more satisfied with civil proceedings if they have the possibility to tell their own story about the case to the judge. And consequently, they might be, they might more easily accept a final decision, even if this decision is to their detriment. And there is a clear link between oral elements and the public character of the proceedings. And for the public character of the proceedings, I would like to refer to what Tanya said before. And she explained how this idea of the public character of the proceedings has evolved over the last 2 centuries. And I would like to add one aspect. If we go back in history and try to identify or to imagine the society at the beginning of the 19th century, it is pretty clear that the only way how to guarantee the public character of the proceedings was the organization of oral elements, of an oral hearing. And that has changed. That has changed fundamentally. Nowadays, we have other means in order to guarantee the public character of the proceedings. In some legal systems, we find a very liberal approach to granting access, internet access to the court files, at least to key documents in the court files. So we have the development of new techniques, how we can guarantee the public character of the proceedings. And at the same time, we can observe that oral elements are losing at least an important portion of their importance. due to the idea of efficiency, proportionality. Lawmakers try to establish new proceedings without oral elements, and the question is whether we can already talk about a phenomenon called the vanishing orality. And we do not think so. Why? There is a new objective that has arisen, the objective to find an amicable resolution for the dispute during the proceedings before the state courts. This objective has gained in importance. And it is common ground, it is widely accepted that it is easier to come to an amicable dispute resolution if the parties have the possibility to talk to each other, either in the courtroom or at least via video conference technique. And so this means that we need oral elements for this new objective that has gained in importance. And that means that we are still observing an important role of oral elements. The objective of those oral elements has changed, but we are still observing an important role of oral elements during the proceedings. And that means that we are confronted with a follow-up question, the question of immediacy. Immediacy, I would just like to say a few words about this terminology. We have discussed this terminology in our team because it's a word used on a transnational level and some transnational instruments, but it is not known in the English of many common law countries. So we were wondering whether it's good to use such a terminology, but we decided yes. Why? Because we want to use a neutral terminology, which is not a national one. So it's for us, it was not a problem that in the English language of some common law countries, this term is unknown and not used. What does it mean? It concerns the situation where we have oral elements, and the question is whether the person who renders the final judgment must be the same person who organizes and follows the oral elements. And there we find very different approaches in the different legal systems. In some systems, we find a very strict principle of immediacy. Other systems have a different approach. And for time reasons, I would just like to refer you to our text. And in order to give more details for that, I would like to share with you a second problem concerning the second chapter. Why? It concerns the overall structure of our part. We have this first chapter dedicated to the influence of procedural rights, principles, and approaches on the structure of civil litigation. And this chapter is a theoretical text, not very detailed, abstract text. And in the other chapters, in the following chapters, we take up these general ideas and give some examples in order to illustrate how these principles influence the structure in a very specific context. And so I'd like to share with you one example. It concerns our second chapter, dealing with the different stages of the proceedings. And just again, in order to give you the background for this chapter, I would like to present the structure of this chapter once again for subdivisions in the chronological order of court proceedings, the pre-action stage, the initial stage of the proceedings, that means filing of the complaint and so forth. Our third subdivision concerns the stages between the initiation of proceedings and the closure of the proceedings. We have called this the mid-phase, and finally the closure of the proceedings and the final judgment. And our observation that we would like to share with you concerns this third subdivision, the so-called mid-phase. In this mid-phase, we have identified several models. One model is based on the so-called apex hearing structure. Another question of terminology. What does it mean, apex hearing? You all know the terminology of trial in the common law systems, or main hearing, final hearing on the European continent and in some transnational instruments. So, for example, in the ELI, UNIDRA, Model European Rules of Civil Procedure. But this terminology is always linked to national ideas of certain procedural systems. We did not have this problem with apex. That's why we have chosen this neutral word. but it means a structure where the proceedings culminate in a single concentrated hearing. And such a structure is based on the principles that we have presented in our first chapter, principles of orality, concentration, and immediacy. Why concentration? Because the idea is that in one single hearing, all key elements of the proceedings are presented to the court, to the judge, so that the court should be able, at the end of this hearing, to render the judgment immediately. And this concerns the principle of immediacy. It's the same judge who follows, who organizes this apex hearing and who renders in the best situation immediately afterwards himself or herself. And the principle of orality, because in general this is an oral hearing. We find different subsystems, submodels, which I cannot present in the given time. And I would just like to draw your attention to all the other systems that we have found, which do not follow such a structure based on an apex hearing. And in those systems, which we can once again divide in subgroups, we can observe that the facts and the evidence are presented in a series of different procedural acts, and it's a mixture of oral-based elements and written-based elements. And now I would like to present some examples of certain procedural legal systems. The first example is Brazil. We discussed the different legal systems of our team members, and then this text was written, and then Alucio read the text and he said, oh no, there's a complete misunderstanding. And this is really interesting from a methodological point of view, because we had discussed the legal systems together orally, with oral elements. And then the text written down was a misunderstanding. And then we corrected the text. And why was there a misunderstanding? Because the Brazilian system is apparently a very particular one, with some aspects that go into the direction of the second model and many aspects that go into the direction of the first model. So finally, we have decided to classify it within the first group, but it demonstrates also the difficulties to classify legal systems. It's not always easy to build up categories. And so maybe, Lucy, you're with us, you might say some details in our discussion. Another interesting system is Slovenia. Aleš, you're with us as well. And if we have a look at the Code of Civil Procedure of Slovenia, we come to the conclusion that Slovenia is clearly a member of the first model, of the first group. But if we have a look at the practice, at the daily court practice, things are different. And then Slovenia is becoming a member of the second model. So this shows how important it is really to have a look at the court practice. Aleš, you are with us. Maybe you might say some details during our discussion afterwards. And the Iranian system is another interesting system, Iran. The rules provide for oral elements. Iran is a member of the second group, and the rules provide clearly for oral elements. However, if you have a look at the daily court practice, we have learned that very often Iranian courts render a judgment without oral elements. So Majid, you're with us, maybe some details during the discussion. And some last words about an interesting insight from this mid-phase. It is very interesting to analyze the interaction, the relationship between legal rules, the court's activity, the court's mission, and the parties' responsibilities and the activity of the parties' representatives. We can identify very different models in this context. We find some legal systems with very precise legal rules, which do not leave much discretion to the judge during this mid-phase. The Spanish system is representing this group. Enrique, maybe some details afterwards. And we have other systems where the judge has much power in order to shape this mid-phase, the German system, for example. And then we have other models, another group, where this mid-phase is clearly party-driven, where the parties have to advance the proceedings during this mid-phase by formulating motions and so forth. So the US system would be representing this group. Linda, you are with us, maybe some details during the discussion. So that's what we wanted to share with you, and I'm looking forward to an interesting discussion. Thank you.
Well, thank you very much, Stefan. Switched off. So now I am also very pleased to introduce to you to Rick Marcus from University of California, Law San Francisco as well, so San University Ascot. And he was, as Burkhard said this afternoon, also a great leader for the segment dealing with access to information and evidence. So, Rick.
Okay, well, thank you. This is my teaching voice. Well, all those in back who can't hear me, please. Okay, good. There's one. I'm going to take you from the high plane to the low road, into the weeds, as it were. Our segment is called Access to Information and Evidence, but basically access to information to get evidence. And I'm planning to introduce my colleagues, and thank you, Burkhard, for the recognition. It's a recognition for us all, each of whom did a chapter which each of them, when they stand or here, they will introduce the title. Those chapters are all posted, so no doubt all of you have reviewed them in advance here, and we can engage in cold calling on that. We're not going to do that. Instead, I want to tell you what we were told a week or two ago, which was, do not spend more than 10 minutes going over your introduction and leave time for discussion. I'm going to try to do that by introducing my team members and having each of them say which segment of this overall package that team member addressed. The team members come from 4 continents. We interacted a lot. We tried to add insights to our chapters from the experience of each of my teammates, and we're all here. We're all happy to talk to you during breaks, over dinner, what have you. It's not clear that it's really workable in this room to get into the kind of details we got into down in the weeds. Mm-hmm. Instead, what I want to do after introducing my teammates is basically make 2 kinds of semi-provocative assertions, and then a concluding observation, and I think stay within the 10 minutes that we were told we should observe. As I see, it is now later in the day. As I said to Luca earlier, he will then be the last person between you and dinner. So I don't want to be the person just before that. So let me begin by asking my colleagues, each of them, to stand and introduce themselves and tell us the title of that colleague's chapter. And maybe I'll start with Goichi Miki. Okay. And remember to use your teaching voice, Goichi.
Okay. Can you hear me?
Yes, can you turn that way too?
Okay. My name is Goichi Miki from Japan. The topic of my chapter is types of evidence. All of you in this room have already seen my paper on that screen as a sample to open to public. So, types of evidence is my topic. And should I?
Well, I bet, yeah. I think that's good enough, and they've already seen it. And as I said, they should have read it too, huh?
I don't have to explain.
No, types of evidence. I mean, you can gather from that
that not all information is evidence you can use in court. That's a big deal. And maybe I would then switch to Leandro Giannini from Argentina, because I think his topic deals with what I just said.
Yes, I'm Leandro Giannini from Argentina, University of La Plata. My chapter is about admissibility of evidence, not the type of admissibility analyzed before the trial begins, the thing about discovery, etc. My topic was related to admissibility of evidence presented or offered to be presented before the trial, after the trial begins.
Okay, so that's related to types of evidence, and then Talia Einhorn from Israel is going to tell us what her topic is. Speaking voice, yes.
Okay, try that. My chapter is evidence gathering techniques, and it deals with everything, what you can do before you start proceedings, what you do after submission of proceedings, what comes after, expert witnesses, what have you, all the types of the ways you can gather evidence, and also how you, to what extent you need to preserve evidence.
Okay.
So each one of us.
Yes, except for me. I don't have one of those things, but that's what I mean by down into the weeds, because those weeds matter. And then finally, Michael Sterne deals with from Germany, but pretending to be English to some extent, deals with where we're going with what we're doing. Michael.
Sterne from Germany, Constance. I was dealing with the ascertainment of facts, and I was told to deal also with the UK because I studied there and I did my best. What I've been writing on was mainly standard of truth, the fact-finding issues, so the free evaluation of evidence, and I'll stop here not to provoke Rick any longer.
Everyone knows to avoid that. So let me try to provoke you with two kinds of assertions that are polar opposites, maybe, and then an observation. And then I'll stop and hope that we can have a conversation during whatever time we have left for doing that. First kind of observation is something I learned starting more than 25 years ago when I started coming to IAPL events. And that is that almost everybody else thinks regarding access to information that Americans are crazy. I'm not going to say that's an unjustified reaction. I will contrast it to almost all American lawyers' attitude, which is, I think by now, based on their experience and being taught things that we teach our students in school, experience those things as lawyers, then as judges. They think that God made the litigation world the way America is, and all the rest of you are not God-fearing folks. So the U.S., more than 20 years ago, Professor Trocker emphasized the U.S. is unique. This isn't civil law versus common law or something like that, but the U.S. is unique, not that everybody else is exactly the same. Enrique has more recently written to the exact same point. I'm not denying that. I'm here to get you to thinking about whether maybe there is something to be said for our way of doing things. But before I do that, let me pick up on something I think Burkhard said earlier, which relates also to something Fernando is perhaps going to be talking about tomorrow morning, first segment, and that is, why would anyone think the U.S. is crazy? Well, here's a story. Here's a Bloomberg Law News story from 2 weeks ago, June 27th, entitled "E-Discovery Hyperlinks Debate Won't Resolve Technical Challenges." What's that about? In most of the rest of the world, if you want to make the other side give you what you think might be evidence, give you information. You've got to tell the judge, this is what I want. I don't have it. The other side has it. It's really important. I need it. Make them give it to us. This story is about our way of doing our system of production of evidence documents, particularly email. That's where, Fernando, this comes into your bailiwick. The latest debate in electronic discovery is whether embedded hyperlinks to cloud-based files in emails and other communications should be treated as modern attachments. That is to say, if I can request the emails, then I should get all the attachments too. What's the problem? Well, businesses now in the last 5 years, in the US at least, have started storing those in the cloud because that seemed like a good idea. Those things in the cloud may get deleted, may get changed. So later on, nobody can find them. And the people who want them say, oh, we absolutely positively need that. And they're trying to hide things in the cloud from us. The cost of doing that, as you can imagine, can be enormous. And we're talking about proportionality. The proportionality dispute, arm wrestling in the US is about using this kind of thing as a club to beat your opponent into submission. Perhaps the sort of thing, just to go off record here, that President Trump has been doing, or former President Trump has been doing in all of his litigation with all that money he raised, alleging he was going to fight the election, but really just to pay for a litigation war chest. There is no perfect answer to that, and I'll come back in my third or my concluding remark by saying that's a really tough call. But if you start out from the end of the spectrum that we're in, which is, oh, everybody has a right to everything, and no loser pays system in the US, and the company often has to spend the money to find the stuff that was linked by the hyperlink, no matter what it costs, that's a huge expense. Okay, so why would anyone, this is perhaps the view of the rest and some in the defense bar in the US, why would anyone possibly want something like that? Well, last March of last year, when we were here before, I used an example I'm going to use again. And I mentioned President Trump. You are aware that we have another election coming up. And we had an election in 2020, which led to certain untoward events, including Fox News putting crazy people, Sidney Powell, on camera. She is now a felon, I think, saying that this Hugo Chavez is controlling voting machines in America and things like that. The Dominion voting systems people who made those voting machines sued Fox News for defamation, for economic defamation. They made a general document request, the kind of thing we're talking about, emails and so on, emails, texts, other communications among Fox News personnel about the election outcome at the time that these broadcasts occurred. Now, could you ask for that? Could you get a judge outside the US to order the other side to do that? Probably. How do you know what it was? You don't know what it was. How can I show I really need that? I have no idea whether they were texting to each other or not. That's one of the reasons I said I'm the only one here who doesn't do that kind of thing, so I'm not vulnerable. But the rest of you all are.
You are. You're now in the cloud because this is being.
Yeah, but I'm not vulnerable in terms of texting. So I don't mind if this is in the cloud. But what I'm getting at is, what do they find? Well, there's a big fight. Fox said, oh, no, it's not proportional, it's not worth it, it's not important, they're just harassing us. But finally, they turned that stuff over. And what we find is that the Murdochs, the Murdoch father, Murdoch son, that run Fox News, and Tucker Carlson, a guy you may have heard of, who used to be a big wheel on Fox News. They were writing texts and emails to each other all the time. Saying, this is all baloney. Sidney Powell is crazy. She hears voices, but they're putting them on there. They're lending credence to that. They are committing defamation. Consequence, $787.5 million settlement. Heaven knows what a judgment might have looked like. So maybe sometimes our method is a good idea, but the fight is there. The proportionality fight is almost always. I've been now dealing with what I call the discovery wars in the US, working on our discovery rules for more than a quarter century. Always, it's going to be the defense side saying, oh, that's all just being used to burden us for no purpose. And the plaintiff side saying, oh, no, they're hiding that because it's really important and that's why they're hiding it. There is no solution I am aware of to that sort of case-by-case dispute, but it's an argument about proportionality. Is this justified in this case? So that's the tension that exists, and now I want to get my final point, shut up. But the final point is, yes, we're poles apart. We're like that. We're moving a little more together. The old continental notion, I can't pronounce Latin correctly, but it's nemer tenetur edere contra se. You don't ever have to turn anything over that hurts you. Tucker Carlson would really like that nowadays. The Ilai Unidua approach rejects that as far as I can see. It doesn't say, however, that you can have what America has. And the American side, this is the discovery wars I see. Whenever one wants to curtail anything a little bit, we are told it's going to be the end of the world. Corporate America will run us roughshod. We have retreated a bit from the broadest view of 50 years ago. We now say proportionality matters. We now have numerical limits. That's really different, but it's closer. So maybe we are not coming together, but coming towards one another. So we'd be happy, even now or later, to talk about what Stefan Huber calls the mid-phase, but the mid-phase is the phase where this stuff I'm talking about happens. So thank you very much.
Thank you very much, Rick, for your provocation and especially for your passion. Passion you show throughout all these years leading your team. So it is now time to open the floor for questions and comments. Yes, please.
Thank you.
Can you please stand up and then quickly introduce yourself, Professor?
Jan Kern from University of Pittsburgh. And my remark is for Stefan Huber. You mentioned that in the oral-based system it satisfies the desire to be heard. And I was wondering if one thinks of this in a civil law, non-common law system, does that imply at all the sense that a judge might not read the writings? And one of the reasons, well, I don't know if this is a reason, but it just evoked in my mind that common law, especially state court judges, so state court as opposed to federal court in the United States, where sometimes one has appellate court arguments and the judges tell you in advance of the oral argument, tell the lawyers in advance of the oral arguments, you have just 20 minutes. That's all you are given. You understand that? Just 20 minutes, no more. And then during this all-important argument for the parties, they are listening to their clerks and nodding off and because they goodness, the oral argument. They also don't read the writing. But in any case, I was wondering what you think of that.
Thank you very much for this very important question. I agree entirely, and it's common ground. I think that the right to be heard can perfectly be guaranteed by a written-based approach. This is not a problem. It's sufficient that the parties have the possibility to present their facts and their offers of evidence in writing, and that the judge reads. So this I agree entirely. Maybe two remarks. First remark, we have a psychological level, which I wanted to address. So this only concerns natural parties or even small and medium-sized companies owned by a family, and they really need to win that case. Yeah. These parties are more satisfied with proceedings if they have the possibility to tell the judge their story orally, and they might be, or they accept the final judgment more easily if they have this possibility and if the judgment is against them. The second remark concerns the evolution of the written-based and the oral-based approach. At the beginning, we had a clear distinction, and the German example is a very clear one. When the German Code of Procedure was adopted in 1877, it was an oral-based approach, but which meant that the judge had only the right to take into account what was orally presented during the oral hearing. And you described perfectly how that works in practice. It's boring and so forth and not needed. And so the practice tried to find ways out, and later on the German legislator allowed the parties and their representatives to refer to the written statements that had been prepared during this nowadays called mid-phase, which didn't exist at that time, by the way. And so we have put this oral-based approach into perspective, and we have made the written statements much more important. Not only in the German system, but also in other systems that we have analyzed that were at the origin based on an oral-based approach. And on the other side, for example, we can observe certain legal systems, even recently reformed systems that were based on a written-based approach, which integrates oral elements in order to allow the parties to come more easily to an amicable dispute resolution process. So we observe clearly a converging evolution. Those systems who started with a oral-based approach have made the written statements more important, and the oral elements have lost a certain portion of their importance, and the other systems have added oral elements. So we can observe a converging evolution in this context.
Thank you.
Could I follow up on that?
Yes, sure.
It's actually an interesting.
Stand up, please. Sorry.
It's an interesting question, Margaret Room, that Vivian asked about orality, and what struck me is that orality is not simply the right to be heard, but it's right to confront witnesses as well. And so I'm just wondering, in a sense, whether from your research, how that is dealt with in a written system. And that's one question. Then the other question ties back to the issue of AI. People were mentioning AI. And what I love about the middle piece of the proceeding is that it's really information coming in so many different ways, right? Whether it's oral, written. And to me, that is the essence of the justice system. It's getting information coming in a lot of different ways. And I just don't think AI is going to be able to handle that. I mean, AI can't necessarily assess credibility. AI can't assess the challenges, the value judgment made with challenges. And I'm just wondering if, in fact, inherent in the way our system is set up, that AI, AI could present one answer and based on data that is written, whereas our justice system presents multiple answers and based on a variety
of information. So, I mean, that's really two observations. But first, if you can mention something about the right to confrontation and how written systems deal with it.
Yeah. It concerns thank you very much for these questions. First question concerns this problem of written witness statements, for example. And if we take the French system, for example, there we find indeed an emphasis put on this idea of written witness statements, which are used as a piece of evidence for finding the final decision. And nevertheless, all those systems which pursue a written-based approach integrate usually oral elements, so that it's usually possible to confront the witness and the parties. But we can clearly notice very different points at the outset, and also very big differences in the daily court life. So in written-based systems where the written witness statement is usual, courts are much more hesitant to ask the witness to come to court. So the differences are existent, but we do not have observed a system where it is not possible at all to confront. There's a question of the daily court practice, as we saw in Iran, for example. Courts very often render a decision without any oral element. And second question, maybe just a few words. The use of artificial intelligence in this mid-phase as assistance for the court. I think that was your question. And I think we have to decide, can you hear me? Is it loud? Okay. I think we have to decide to distinguish between two different levels. The first level concerns the fact-finding and the taking of evidence. And the second level concerns applying the law to the facts that are established after the taking of evidence, after the evaluation of evidence, and so forth. And we have to distinguish between these two areas. And we use already in AI in order for the second level, in order to apply law to given facts. And then we have a certain probability at the end as a result of using this AI tool. It is much more difficult to use AI in the first context, in the context of fact-finding and the taking of evidence. So I think we have clearly to distinguish, and in any case, I think we should not forget that there might be problems of independence of the judge and so forth, if the judge trusts entirely in an AI tool. And one last sentence concerning that, we might imagine maybe two instances. First instance, where we use really AI, and then the party should have the right to ask for a decision taken or rendered by a human being in a second instance. That might be an interesting system, because maybe many cases don't reach the second level. So, but I'll stop here.
Thanks. Rick, you have a remark?
Well, I think I have a remark about Margaret's first point, just between the ideal, if it's ideal, and the real. The real in the US is we don't have confrontation in court with witnesses on which decisions of courts are made.
I disagree.
1% of civil cases go to trial.
Yeah.
Summary judgment is not the same thing. That's much more prevalent because of our right to jury trial. Judges can't decide unless it's really not disputable. So most cases, like the Fox News case, settled. There was no trial there. Unless you consider depositions a good substitute, which they might be. You don't have decisions of courts based on confrontation.
Well, in the federal court system, maybe it's 1%. In the state court system, it's much higher. So you still get that thread shadow the law. But this is.
You leave it. So,
okay.
Remo had a remark as well, please.
Remo Capuri, just a question to Stefan. Would we say, as a general take, that the ethics hearing model is more apt to push for orality and the the other way around, that the sequence, it's more attributes for victims.
Yes.
That's a general. Yeah, because this is, of course, was my impression. So,
maybe we have to be careful because those models which use this apex hearing structure, they have a very important phase in order to prepare this apex hearing. And this, yes, in Germany, for example. And this phase can be a purely written phase. So then the exchange of written statements is very, very important in order to prepare this apex hearing. And if we have a look at the daily court practice in Germany, in simple cases, which are not very complex, the apex hearing is very short, and the representatives of the parties just refer to the statements, to the written statements that have prepared the apex hearing. And in such a case, if it's a simple case, not very complex, no complex legal questions, then in theory, the apex hearing is the final important point, but the real preparation has taken on a purely written basis. And that's what the judge takes into account for coming to the decision. So I think it's difficult to say that if you have a look at the daily court practice, those systems are working with the apex hearing structure are really oral-based systems. Yeah. It depends on the case. For complex cases, that might be so, but for easy, simple, day-to-day cases, no.
Okay, thank you.
And if I may, I will abuse my position here because I participated in this chapter. And well, Sabrine, you know the Belgian system well, and Vanessa is here as well. So we understood the Belgian system as not being an apex hearing system, even though the Belgian system is well based on orality, because there is an introductory hearing and then there could be a second hearing, but none of those hearings are apex, so to speak. So there's not such a clear connection. I don't know.
So one is from a bush.
Why wouldn't you stand up? So
why wouldn't you qualify the Belgian as not as an apex? Because in my understanding, it's maybe Yannick had another opinion, but in my understanding, it's a final hearing in which arguments are often reproduced orally, and afterwards is taken into consideration, and decision is made both on the written pleadings and on the oral arguments that are sometimes also limited to, you have 20 minutes, nothing more, it's almost noon, so I want to round up this morning. So I thought, without knowing before it was.
So, and we could discuss this further, but what we gathered from Yannick, who is the Belgian member of our team, is that these hearings that in the Belgian system are essentially used to present the case. So to explain the oral arguments of the parties, whereas the taking of evidence happens separately in different sessions. So it's not happening in a concentrated manner together with a presentation of the case. So they are hearings that has as an aim just to present the case to the judge, or to discuss or rediscuss the judge when there's a follow-up hearing. But the taking of evidence is scattered, so to speak, here and there in different sessions. That's why we did not regard the system as an apex hearing, the Belgian system, even though it's based on orality for the purposes of presenting the case.
From that perspective, I would, but of course it's a theoretical discussion, because sometimes you have, like, if you argue your case, you try to go to the judge, but here we have this document and it's literally indicated there what we are arguing. So it's not that we will call a witness, that will happen on a different hearing, but still, like, evidence is present somehow in the final hearing.
In the hearing, okay. Burkhard?
I have a different point, but a real question.
Please, would you stand up? So
today, can we really distinguish clearly between the written phases and orality? Are we changing a little bit our ways of communication, and what does this mean for the classification?
Yes, Should we just take the second question?
Yeah, well, maybe
Just follow up on this question.
Alan, please. So people can listen.
I'm just wondering whether it is time for us to also question whether the opposition between orality and writing is an old-fashioned and outdated one. In procedural law, we may probably take the example of substantive law. The United Nations have since the end of 90s replaced the notion of written form as a essential part of the contracts from law on electronic commerce by the notion of record. And of course, the opposition between orality and writing was very important when it needed days and weeks for a writing to come into court. And therefore, of course, orality was the immediate communication. Now you have the merger of writing and orality, and it's technically possible to, and maybe some other oppositions like instantaneous communication or consecutive communication as is one possibility for that, or forms of communication with a record and without a record. Well, it was recorded. Whatever he's told us about president, former president, future president is now already in the cloud. So well, thinking about what the orality and the writing are being used for nowadays, maybe probably again problematized a little bit.
Yeah, very important question. Thank you very much. And that's indeed the interesting points which we have analyzed. First question, what does it mean, orality? Second question, do we or can we clearly distinguish between both systems, written-based systems and oral-based systems? As to the first point, what does it mean, orality? For us, orality is defined as a situation of simultaneous conversation. Okay, so that is clearly a very specific situation for the parties, first and foremost for natural parties, to have the possibility to tell to the judge their story, either in the courtroom or via video conference technique. But it's a possibility to interact simultaneously. It is true that nowadays we have developed other techniques of communication where we leave a message, an oral message, somebody else listens to that message and gives an answer. It's not for us, this is not simultaneous. It's another technique that might be used for dispute resolution of small cases. That might be an interesting model that we find some tendencies. But for us, orality means simultaneous conversation. And then we can clearly say that this has certain advantages for natural parties in a certain context. But at the same time, we have clearly observed that both, as I said, in the 19th century, we clearly distinguish between written-based approaches and oral-based approaches. And nowadays, we can clearly observe a convergent evolution. Those systems that were based on a written-based approach have integrated important oral elements, and the written statements have put into perspective, and vice versa. So for the other type of model, we can observe an evolution in the other way, in the other direction. So there's clearly a convergent evolution.
I have one additional question. One, two, okay. So we will just collect the questions together and then put them to the speakers. So first, Jordi Nieva.
Yes, I was paying big attention to what you were saying, because I think you came to the right point. What do we want orality for? This is the right point. And I have just one little question based on witness psychology or testimony psychology, as you call it. Does anybody in this room can tell if someone is telling the truth staring at his or her face? Because if there is no one here, no judge can do it. Yeah. And all our system is based on the idea that judges really can do, as Jeremy Bentham said back in the 19th century. So, I mean, if we take this into consideration, and there is a big scientific basis to say what I am saying, there are more than 50 psychologists in the world, that Saiga Manifesto to say,
ringing the bell.
please stop telling the people that you can tell if they are telling the truth or not. You are not doing the right thing. So if we take this into consideration, does orality have still a sense? In which way? Maybe it has. I think it has. I think it has, but not in the assessment of evidence. Thank you.
So we will collect the other question and then Jill.
Yes, so Gilles University of Luxembourg. So we've got a question for Rick Marcus. With respect to the distinction that you made between the American way of discovery in particular and the way of all the others. And I was wondering, I was thinking about a book written by Robert Kagan on the American way of law. And basically what he explains that there are so many things that unique to the US as a procedure, because the US uniquely uses litigation as a mode of government. And so that's why the rest of the world doesn't have a number of things. But it doesn't really focus on discovery. And I was wondering whether that could be a possible explanation, whether that would be part of the promotion of litigation, uniquely promoted by the US, or whether it would be a different story.
So first Stefan, then Rick.
So just one remark to this very important question of the objective of oral elements. I personally, I think indeed that for the witness examination, orality is not useful. Why? We have very clear results from psychological research that it is even misleading if a person looks at the witness when the witness tells their story. So it is really very difficult to draw any conclusion from the behavior of the witness. And so the best thing would not to see the witness when the witness tells their story. Yeah. So maybe an oral element is not so bad for the witness, because for the witness it might be easier just to talk, to speak. So we have this oral element, and it might be easier to ask questions. So we have also this element of simultaneous conversation. But oral, if you add to the idea of orality, the idea of being confronted and to see each other, this would not be useful for the witness examination. So you can even distinguish between orality without seeing each other and orality in a situation where you can look at each other. And then psychological research is very clear, and looking at the witness is not a good idea at all for witness examination.
Yep. Thank you very much for that question, and I'm going to say more than most of you might want. Bob Kagan's book, Adversarial Legalism, now in its second edition, came out, I think, around 2002. Since then, in 2010, another book called The Litigation State by Sean Faring, Princeton University Press, deals with a different aspect to what I think is the same thing you're talking about. Yes, one of the big pro-discovery arguments is we don't rely on the government to enforce public law. We rely on private entrepreneurial lawyers to go after the Sacklers, for example, the opioid disaster. And they don't have the power of the government unless the government gives them this authority through court authorized, enforced right to information, which can be used as evidence. So yeah, that's another big divide. I could even lapse in talking about American procedure as populist procedure, jury trial and jury awards of big dollars for punitive damages, law, pain and suffering and what have you, reduced judicial power to decide things, which gets back to my point about summary judgment. You're absolutely right. And that's just another kind of brick that people throw at each other in the discovery wars in the US, where it's really little tiny changes that get people throwing bricks. And I'm the guy on the receiving end of the bricks from both sides.
Yeah. Because you are responsible for that in the committee. Okay, I think we will just leave it here. Thank you very much, Stefan, Rick, for the discussion. And please don't move. We still have one more presentation to go. So I invite Luca and maybe the whole team to stand up here.
Send you that stuff. Okay.
Isn't there a lot of research that talks about body communication?
Oh, yes. And
Yeah.
also,
So that's,
12 ordinary people are better than one legally trained person to make.
that's what I was just trying to say about morality. It's like keep the body communication. So I would definitely. Well, that's amazing to me. That they but that's
Sí, sí, sí. En el centro yo creo que es más mejor, sí, porque eres el coordinador. Who else is missing?
Where is
We do have the. Do you have a presentation?
Yes, we do.
Yeah.
Okay. Okay. May I have your attention, please? Thanks, Rick. So may I have your attention, please? Yes. Take a last breath and only a few more minutes to dinner. So it's not that we're going to have 5 presentations, just one presentation. This is the segment devoted to the final judgment and appeals, and it was led by Professor Luca Passanante from the University of Brescia in Italy. And I simply hand it over to you, Luca, so you could also lead the way and introduce your colleagues.
Thank you very much. Hi, everyone. It's late. We are all tired. Thank you very much for being here, the survivors. And, well, I thought the best thing to summarize very quickly the work we've done as a group was to involve all of them, all of the members of the group. I can and I want to say very, very few things, not very technical, to be honest. And maybe I think, and I'm sure, I'm also expressing the feeling of my mates. We are all, the members of the group are all, I think, happy, proud, and grateful for being here. This is very important because, the task of this project is really challenging. It's difficult. So we've been working together for about 2 years, trying to meet online from time to time and to stay together. And we are very happy to have the chance of staying and of working here together today. And we also want really to thank for this opportunity the directors of this work, Burkhard Hess, Margaret Hu, Séverine Ménétré, Enriquez Ballines, and Lloyd Cadier. So, saying this, I have thought that the best thing to deal with our segment was to let you know the table of contents of our works. And every member can very, very quickly explain to you the subject matters they dealt with, and if, as far as possible, why they've chosen this approach. We have tried to discuss it together, and then everyone, of course, have done her own job. These are the valuable mates working on this segment. Victoria Arsagi, Daniel Mitidiero, Victoria Arsagi is from Hungary, Daniel Mitidiero is from Brazil, Carlo Vittorio Jabbar is from Italy, Gerard Ken is from Canada, I'm from Italy, and Injin from China. So I want to leave the floor now to Carlo Vittorio Giabardo, explaining the content of his, very, very quickly, briefly, of his own part. Availability of a first appeal. Please.
A common law inquiry. So thank you to everyone. I join Luca Passante in thanking and stressing the fact that we did authentically comparative law research, which is not foreign laws. So it's not simply to put together, in Canada we do like that, in Italy like that, but to do engaging in a comparative discussions. So my chapter goes in that direction, and I want to focus the attention, especially in the first part, which is theory. So we have in the other slide, practice. So more like what happens in the concrete way in each jurisdictions in the second part. But the first part devoted to theory. So we divided appeals. My topic is first appeal. We divided appeals between me and Gerald Kennedy. I was assigned the part on availability of a first appeal, and Gerald Kennedy the part on the scope and reviews of and the content of appeal. So I focused on the availability on first appeal in comparative perspective. The first part was dedicated to explaining my methodological commitment in comparative research, which is comparative law of differences. It means that I do believe that the task of comparative law is to make differences emerge and to explain differences. Although we are aware that common law and civil law jurisdictions, also in civil procedure, are converging. There is the convergence element in common law and civil law, and in civil procedure it's doubtful if they are converging. And I'm saying, yes, they are converging in appeals, in treating appeals as luxury goods. They are converging in a sense. But we, as comparative lawyers, we should make differences emerge. And I explain those differences, not just in technicalities in appeals, but in the mentality, in approach in appeals. So the first part 2 and 3 of the first part is dedicated to explain conceptually what's an appeal, to make them comparable. So we need a concept of appeal, and appeal is a way, is a strategy of a legal system to strike a balance between two needs. The needs between justice, to have correct decisions, to have revisions of errors, and stability, which is res judicata. So appeal a strategy to strike a balance between two needs. And then what's the principle of the double degree of jurisdiction? I'm not sure if in the common law they say double degree of jurisdiction properly. I found a lot of literature saying double degree, but from foreign scholars. We say doppio grado di giurisdizione, il doble grado di jurisdiction in different languages. It means that the jurisdiction is divided into layers. So there is 2 layers, and most of the legal system of the world protects this right, although not constitutionally. So there is the discussion if this right to a first appeal is protected by the Constitution or by supranational charters. And then appeal between, and I'm just finishing my part, between declamatory statements and operational rules, which is a contraposition of Rodolfo Sacco. Because we see reading comparative research in appeals, declaratory statement, rhetorical statement, appeal is a right, right to appellate review in the website of the judiciary, appeal as a right, thinking appeal as a right, but then if we go to operational rules, we see that appeals are very limited in various ways, subjected to discretionary choice by or discretionary decision by a court of law. So I'm trying to put the concrete manifestations of appeals in current jurisdictions within this framework. So the second part, common law model, civil law model. The word model, it's not random, because in doing comparative research, we deal with models. Models, it's not something that exists. Model is an idealized generalization, okay, in which to put concrete specifications of appeal. So in second part, I focus on permission to appeal, which is a form of limiting appeal, limiting the availability of appeal in the common law jurisdictions, especially in the UK, and then the attempts to limit, to copy, or to import this UK model of permission to appeal, filtering of appeals in civil law jurisdictions, especially in Germany, where this filtering of appeal still exists, and in Italy, where this filtering of appeal doesn't exist anymore, but it has, there is a discussion about the pros and the cons of this filtering of appeal. So that's the structure of my work in comparative research.
Great, thank you very much. Gerard?
All right. So, as discussed, my topic is the scope and standard of appellate review. I had 6 minutes prepared, but I think we all want to get it here, so I'm going to try to break this down to 2 minutes with one takeaway that you'll hopefully remember. If there is an overarching theme that you see in literature appearing, say, civil law jurisdictions such as France, Italy, Germany, which are the three I analyzed, compared to common law jurisdictions, I look at the UK, Australia, and Canada in appellate practice, is that the common law jurisdictions usually have very broad appellate powers when it comes to determinations of law, and very limited appellate powers when it comes to determination of facts. I think this is reflective of the fact that common law judges are very open. It's part of the institutional design, that they delineate and refine legal rules as they develop through case law, and the higher up you are in the appellate hierarchy, the more that role is important. On the other hand, given the adversarial system, if parties don't lead evidence at trial, they shouldn't be able to get another kick at it at appeal. Whereas in an inquisitorial system, that concern is much less salient. You often see in France and Italy, the literature refers to have an appeal that is in reality a chance to have a second trial. That is the overarching stereotype. You look in what I look in the chapter, it's a stereotype that exists for a reason, and yet I think you see in recent decades a surprising amount of convergence. In both Australia and Canada, you see discovering areas of law that look an awful lot like interfering with findings of fact, such as the determination that a finding of fact that has no basis in the factual record is itself an error of law. And you see, and this has recently been done notably in Italy, changes to appellate practice that put a clear burden on the appellant to show why the decision is wrong. So like the tie goes to to upholding the result, to a screening mechanism to get rid of appeals that clearly have no merit, as well as more and more restrictions on the ability to introduce new evidence on appeal. Basically, if the party acting diligently should have introduced to that trial, they don't get to do it on appeal, notwithstanding the inquisitorial system. So these view that, more of a second trial in civil jurisdictions, not so much so in common law jurisdictions, but common law jurisdictions have great interference on determinations of law. That is a stereotype that exists for a reason, and yet in recent years we're seeing convergence. that's kind of what I want to leave you with, and I don't want to keep us between now and dinner anymore.
Thank you very much. Now I have to tell you some words about my work. My chapter is about Supreme Court and final appeals. I decided to start in dividing courts, Supreme Courts in different models: cassation, revision, and appeal. Then I will discuss in my work the way of access to Supreme Courts, dividing them into models as well. The first one is a model which now is about to be abandoned by every country almost in the world. Is free access, but Italy is a good example on this. Still, theoretically, we have a free access to, we have a right to appeal before the Supreme Court. Then we have a very common model emerging nowadays, which is the one that introduces filters, so limitations to appeals before the Supreme Court, and then the certiorari model. Then we have to deal quickly. In my chapter, I deal quickly with models of decision making of Supreme Courts. This part partially overlaps with a chapter by Daniel Mitidiero, so it's just something very quick. Is trying to distinguish between legal model and attitudinal models, and trying to explain that in many occasions Supreme Courts behave in a way that it's in between these two extreme points. Then another important issue is the relationship between Supreme Court and Constitution, and the relationship between Supreme Court and Constitutional Court when it's present. Finally, the last part of my chapter deals with Supreme Court and judicial precedent. And this is almost, I mean, is the part I like more. And there is a general introduction, then the explanation of the traditional contrast between binding and non-binding precedent, which I believe it's a very weak distinction, and something about, I mean, a part trying to explain and to understand how the precedent actually works. And another part is about the relationship between the judge, the role of the judge, precedent, and the law. And then trying to use this contrast between precedent of solution and precedent of interpretation. So this is more or less what I have, what I've done in my chapter. And then I leave the floor to Ingin with the most difficult chapter about res judicata. Poor Ingin, working a lot. Please.
Thank you, Luca. And after I hand out my my work to the team, I realized the meaning of a Chinese word said distance produce beauty. Means for I stand from the Chinese law. When I look the American law and German law, we can say two examples and two heroes of these two systems, and both are very beautiful for me. And I understand the German way and the American way. And I will go to the details. For example, in my chapter, I deal with two main questions. And the first is when a judgment becomes final, which part has binding effect? And then when we answer this question, we need to ask who will be bound. And at first, when to reach the details, it's difficult to understand. But when we keep distance, we can find there are so many common cores in this difficult area. For example, which part of the judgment will be bound? And it's in Germany, also in USA, and also in other countries. The first common core is the conclusion of the judgment will be bound. And then the litigators in the first case want to challenge this conclusion. No jurisdiction will allow the second litigation. And the problem is, and we can call this is so-called claim preclusion. The problem is the claim itself. What means a claim or the cause of action is not self-defined. And we have many problems here. But I don't think it's a problem of comparative civil procedure. It's just the different balances in different countries. For example, in Germany, they hold private autonomy at the top. So in the first case, the litigant can determine which is the claim. But in the USA, it's a different case. In the USA, we can see private autonomy has no role to determine, but the transaction or the story itself is the most important. And the Chinese law goes to very conservative. In Chinese law, both the claims, the private autonomy, which the determination of the parties, and also the legal, the material laws. So in Chinese law, a single action in USA will be segmented in China for different litigations. And the second is the so-called, after we have talked about the final, the conclusion, and then how about the facts and legal determinations in the first case for the second case? Then the second case deals with different claims. For example, from the same accident, there may be different for salary and medical costs. And in the USA, the determination in the first case will be the basis. And in German law, it's not. And in Chinese law, we follow USA in this point. And why? Because we couldn't tolerate contradictory determination in China. And then I go to the second point, the objective, who will be bound? And then we can find a second common core. Only the parties and the successors will be bound. But Chinese law is a sole exception. And in Chinese law, the binding effect of judgments will binding all the individuals. That means all of us in this room. And why? Because we also couldn't tolerate contradiction determinations, both for the parties and also for a third person. And the second reason is very interesting. It's the misunderstanding of comparative law. Why? For example, in German law, we have specific rules about this point, but in Chinese law, we don't. So we think German law only binds the party because they have this regulation, but we don't. So in our system, the judgment will bind all the individuals. So after I hand out this paper, I have the feeling the res judicata is live fossil of civil procedure law, and it's the witness of the development of civil procedure law, and itself is also in development. Thank you.
Thank you. And last but not least, because is one of our most important members, Victoria Assange, about the reopening the case. Thank you, Victoria. The floor is yours.
So it's not an easy task to speak as a last speaker before the dinner. Everybody is hungry.
The order was because it had a logic. We agreed on it. Okay. Victoria.
We somehow share the extraordinary remedies with Luca, and my chapter has the main focus on the reopening of the cases. But there are big differences in the approach of the different jurisdictions in this field, and that's why I think I could not follow a traditional structure in my chapter, so I needed a longer introductory part where I seek for the reasons why some jurisdictions are not only an anti-appeal jurisdictions which do not make a broad possibility to the appeals as well, and it's much more this opinion is much more valid when we see the extraordinary remedies. So I would like to speak about the philosophy of the chapter, what philosophy is based on this chapter. There are in connection with the remedies, they serve both public and private purposes. The private purpose can be the protection of the right of individuals by correction of the judicial errors, and the public purpose focus on the need of clarify development of the law, uniformity of the law, avoid injustice. What are the aims of the remedies in general? Need to correct the errors, accuracy, lawfulness, public face, development of the law. And on the other side, we have to see other values as well as legal certainty and effectiveness. And these values are struggling in the different jurisdictions. And basically every jurisdiction try to create a balance between these values, but the priorities are different.
Sorry, can you speak a little?
Yes. So I will focus on extraordinary remedies, and in this field, the reopening, the structure of the procedure, the view expressed about the purpose of the procedure in the given tradition, basically determine whether they are such extraordinary legal remedies and what extent they are possible in the given jurisdiction. We have
louder. I mean,
Yes,
louder.
I try to speak up a little bit. I don't want to go into the specific findings of the chapters due to the lack of the time and because the chapter is not ready yet. So
but almost.
It's almost ready.
Almost ready.
I can finalize it in the summer, during the summer holiday. I spoke about the introductory chapters, which will my focus based on, and you can see on the slide the table of the content of the chapter, which is partly draft. The end of the chapter, I will have in my chapter the availability of the reopening, what courts are competent, what are the preconditions of the reopening if it's available in the jurisdiction, the time frames, introduction of new evidence, how the procedure takes place, the retrial takes place, inclusive case management, time management, efficiency, and what kind of decision we can reach. And of course, I will have in my chapter a conclusion as well. Thank you.
Thank you very much. Just if I can say just a couple of words, because you are not the last one, because Daniel is Daniel Mitidiero, is the last one. He's not here, but he will. It's chapters, his chapter with the duty to provide written decisions in civil procedure, and this is the content of his chapter. I really want to thank my really valuable colleagues here, members of this segment, and I really want to thank you for your patience and Enrique for chairing this roundtable. Thank you very much. Nope. No.
So, on the request of the team leader, I would propose that any questions, comments, remarks that we have to the team, you all can see who are here, are made on our way to dinner. You have further questions? Okay, when the main editor of the project has a question, I will give you, so please go ahead.
Well, it's a very interesting segment, and I'm very much looking forward to receive additional chapters. I already got one, but there's one thought which came into my mind. If we look at appeals and second appeals, let's put it the English fashion, I think this is a very interesting area where we can wonder, and you did it, whether we really have the divide between the civil and the continental growth. And one way to overcome or to get better information here is certainly empirical research. Empirical research in the sense how many decisions are appealed, how many second appeals are permitted, and also extraordinary appeals. I have learned Austrian procedural law during the last year, and one of the very interesting takeaways was the structure of the extraordinary appeals in Austria. They are not so much extraordinary. They are more or less a continuation of the first instance proceedings in case there are serious deficiencies we would usually in Germany bring to the appellate court. So I think if you combine this within the team also by asking for some statistical information,
yes,
this might be a very good added value for the whole project. Thanks.
Thank you. Thank you very much. We will, of course, follow the suggestion because it's very interesting.
Yeah, in first appeals, the difference I think the difference is important because I make a contraposition between first appeals as an unconditioned right and an extraordinary remedy based on statistics. So appeals, first appeals and second appeals are statistically way less relevant in common law jurisdictions than they are in the civil countries. Two attitudes to.
I made a mistake.
It was the last one.
No, it was. I mean, answers are forbidden, not questions. you can make
No, but
no, I'm joking.
If anyone has an additional remark or question that would like to share with the audience, I will allow it. So
just
Raymond Caponi.
Just a remark. We noticed that we have two chapters dealing with judicial reasoning. One is from Hermes and the second is from her procedures, and it's interesting and talk to each other. It's a difference in the approach dealing with judicial decision in the framework of the town, and dealing with judicial with the duty to give reason within the framework of your just
no, it's a perfect legitimate question, but I don't have the answer because I should ask Danielle, and I don't know if they. I suppose they did, but I don't know. So I will let you know.
Last question or remark on our way to dinner.